Hello everyone, I'm Leonard French, your favorite copyright attorney. Let's do a mic check and a video check and a quality check, and let's get some feedback here as to whether everything is working properly. Hello chat. Hello Zarek. Razgriz Reborn. Razgriz Reborn asks, can we ask questions? Yes, you can ask questions. Mike Novelli gives $2. My service to the YouTube community is invaluable. Thank you, Mike. Looks like everybody thinks the audio sounds good. Excellent. Welcome, everyone. I am Leonard French, your favorite copyright attorney, and I'm here tonight with an update, or the latest update. I don't know. What do you start saying after there's just so many updates? To the Imagos Softworks, the Mazer DSP, Alex Mauer takedown DMCA abuse debacle thing that just hasn't really been able to go away or be resolved really to anyone's satisfaction quite yet. And so we're going to talk about where we are in the middle of all this right now and how we got here and where we're going. And there might even be an appearance by someone who is involved in the case and the matter. Let me pull up my notes here and see what else I wanted to do. Yes, let's remind everybody that Mazer DSP is back up on Steam. You can purchase the game for $9.99. It is in early access. The quality is good. The game is fun. It is hard. There's progression to it. It is a roguelite shoot 'em up shmup game, and it is very, very good. I highly recommend you check it out. We will be playing some of that a little bit later. Thank you, Yasho, for the $2. Thank you very much. I appreciate your comment. He says he likes my hat. All right, so without further ado, I thought maybe we would say hi to someone who has been involved in the case here for a little while and maybe hasn't gotten some of the airtime that he deserves, and I believe that there's even someone joining him. So let me see if I can get a hold of Mr. Thacker. All right, are you there, Mr. Thacker? Let me bring up Skype, and let me bring up... And oh yeah, see, every time I switch, it changes. So let me do that first. There we go. You are on stream, and I am not. I'm not. You are taking over the stream. Yes. Let's see. You are invited, and I have absolutely no idea what happened to my camera when I switched the scene there, but I'm gone, so it's just yeah. So I've got there's a hat. The dogs are in the other room because they know that when I'm working, I don't want to be disturbed. What have I done here? Okay, I'm over here. My camera's still working, but you're over here. Okay. This is the best stream ever. So, you can't be heard. You're on my desktop audio. Okay.
Everything is gone.
There
Tell
we
us
go.
when they can we be
How
heard
about
now?
that? Now I think they can be heard.
Wow, hello. Welcome
Okay.
to Leonard French's stream.
By Don Thacker.
Except, wait a second. Somehow the video is now frozen.
Oh my
Great.
God.
It's the best screen as well. Look at that. Look at my face.
Listen, everyone, we're all professionals
This is
here.
the best.
We can handle this.
I've never done this before.
I saw someone say this is so amazing. Excellent.
Yeah, it is.
That's
this
great.
is exactly how every single video conference starts from the history
Right,
of
this
man.
is a real world experience. We had a video conference
Just
earlier
today.
today
Yeah.
that was
laborious,
tragic.
very difficult, incredibly hard.
Here, what if I put this up here? Kill that. Okay,
I love
so far
that
we're
image.
doing
That is
better.
a great.
That's the
that is a
best
great
picture.
priest.
Oh, there we are.
Oh, well,
So
moving
far
on.
we're doing better. Now how can I get myself on top here? There we go. Wait, no. Order. Move to top. That's not doing anything. Why is this not doing anything?
Love this. This is my favorite thing.
Transform. Center to screen. No, that's not doing anything either.
Well, this actually leads into another interesting issue that Don and I had earlier today.
Yes.
We were trying to put some text overlay
Right.
using a third-party program.
There's going to be all like Don Thacker, Skinny
It was
Tie.
going to make us look like we knew
like
what we
Twitter
were doing.
handle Skinny Tie, and it was going to say Lindsay Peck. Pepper
But when
Place.
you put it into Skype, it was flipped.
Yeah, it's a big mouse.
And we couldn't. I don't know why I did that.
Troubles. Major troubles.
It's ridiculous.
Okay, it's telling me that I
You should be
can't
looking
use...
this way and not that way. If you want to
I'm
move
trying
this
to
way-
read
Oh, you're
text and
fine.
engage with our
But
audience.
Oh, you're
it's
fine.
just your face down this way the whole time.
The whole
This is
time,
not-
I'll look here. I'll
This
be
is
like,
not
hey guys,
interesting
what's
for the
up?
audience.
And then I look back up here and be like, hey guys,
No,
what's up?
have you ever watched multiple people's streams and there's always like the fat guy on the left?
Oh, here we go.
They're all doing the stream thing, and the fat guy on the left is always like this the whole time. You're just like, and he's not paying attention to the whole stream. You're gonna.
Are
be
you
the
calling me
fat guy
the
on
fat
left.
guy on the
I'm
left?
technically the fat guy on the left. You're gonna be analog to the fat guy on the left. This is crazy. Do you want to put that YouTube?
It will not
Why
let
don't
me
you
turn
bring it
my
up?
camera on. My webcam is just
We should just move.
caught in limbo between OBS streaming and Skype.
Yeah.
Oh, no.
We actually had things to talk about. I think there was a plan. I was going to talk about.
Well, that's
something.
okay. You know what? I can do some manual switching back and forth here.
This is like you're going to be the guy in the station.
I'm going to be the guy in the station. Now, I'm still here. I can say my thing, and then we can
We
switch
look like
back
we're
to you
coming
guys.
up in a little
So,
box
how about
with like
that?
a little 480.
That's going to be the best
box.
that we got. Sorry.
Great. Welcome to the internet, ladies
How
and
are
gentlemen.
you,
I'm
Don?
Thacker.
I don't get to
Great.
see your face very often.
Yeah, no, so totally. I'm as great as can be in the given circumstance, but better today than perhaps days prior.
Yeah.
If that makes sense.
Yeah. Why do you feel? Why are you feeling a little better today?
Things are calmed down a little bit, as we've noticed, and there have been no initial or ongoing sort of attacks, and our position with you seems to be pretty great. It seems to be that we've done all the right stuff. That's always been the plan, is to make sure that we just do the right thing like the entire time, and it feels like we've done all of the right steps, and we're just kind of. I don't know. It's not as stressful as when we didn't know what to do, or we didn't.
Right.
Yeah, when things were kind of crazy.
Yeah, it's been a long way to get here. It's
Yeah.
only been about a month between for our relationship, me and you guys, and then the whole situation. But you've been going through this for a very long time.
Yeah.
And the relief that you may be experiencing now is relief from this kind of very complicated situation that just recently came to a pretty big head. So,
Right. I mean, it could be easily said like you're in the middle of a legal discord. There's about a bunch of issue happening. There's all this stuff, but in reality, this is the least amount of it in the most compressed amount of time. So it's actually like it's the only thing that I've had so far that's had like a clear, like there are dates attached to things, and things could actually go potentially okay at some point in the future, whereas before it was kind of just like this dread horror into the future, no knowledge thing. I don't know.
yeah, not really knowing when it was going to be over or
Right.
how, and now at least you have some dates and some things to look forward to.
Yeah.
So let's talk about the positive things. What do we have to look
Sure.
forward to? What's going on right now with Star Mazer and your side of things?
Well, Star Mazer DSP is back on the Steam store, which is pretty great. It's the early access release, which is what we released in August, only it's been updated, and there's all that sort of early access work that goes on between the time you launch an early access thing and months later. We have been hobbled a little bit in time because it was taken down from the Steam store 3 separate times. One time was not an official DMCA takedown, but rather a voluntary takedown, but it was in response to a DMCA claim. So to be clear, there was an official DMCA claim that took us down off of Steam. We replaced all of the music, removed all the stuff, put it back up, and then there was claims made against the sounds themselves with an additional threat of like asset level claims in the future if we decided to replace sounds. So we decided to then voluntarily pull it down, replace everything, and not respond to the claim. At that point in time, my goal was to remain as non-litigious as possible, to respond legally as little as possible, outside of sending offers and having some form of official communication between our contract lawyer, Chris Reed, and the other party. we worked very hard to not actually engage at that level, to not just hope that we could work it out as human beings. Unfortunately, that was not able to happen. So the third time was an official DMCA strike, which was to do with a sound in an archive branch of the source code that wasn't used in the game or whatever, but still it was there. And what we did is actually counterclaimed the initial all sounds claim, which covers every single sound in the game. So we didn't counterclaim a single instance of a sound, which could open us up to more other instances. We just counted all sounds, including VO and everything, every sound element in the game. So now it's up, and we are told by Valve that it is protected from DMCA claims for music and sound, which is great. Everything else is appropriately. I'm sorry, everything has been appropriately contracted and copywritten and whatever, but people who would attempt to make claims on sounds and music can't do so any longer. And
in particular, we've also received an order that Alex Maurer herself can't DMCA the game any further.
Sure.
And I'm going to go over that later in the live stream, so don't you worry about going over that now.
Excellent.
Is there anything else you'd like to say? I don't want to keep you guys busy for my whole live stream, so I'm going to let you guys go do your own thing. And
your whole screen. We've taken over everything, so you couldn't possibly leave us here because we would just own the screen the whole time, and you don't want that. That's the worst. My big face, half of your screen. That's terrible.
Well, I'm here to balance it out.
Yeah, you totally do as well. No, we've got, let's see, Star Mazer proper is, it's been pretty hobbled since autumn of last year when events caused a very reasonable concern with our previous publisher. I say very reasonable because I always attempt to put myself in all the shoes, and it seems like if somebody were to come to me and say, hey, these things are happening, I might go, oh yeah, I don't know if what you're doing makes any sense, man. Like you just threw a bunch of money at somebody, walked away. I don't know if that works, and it's our money. So that was pretty rough. So in that regard, it's been kind of difficult it's been incredibly crushingly difficult for a very long time. But it seems to be that this has sort of, this situation is the nuclear option, but it is an option. So things are getting resolved, and they will no longer be problems. And our initial talks with additional publishers or partners have always kind of, in months prior, levied up against this, like, yes, but what about this problem? How do you intend to deal with it? And my response of, I don't know, I'm like super trying to make everything make sense, and I don't really have an option. And, we had our prior publisher actually requested that we, should we actually believe we were right to actually litigate? And unfortunately, that's if we need money to make a game and we're missing budget to make a game, and somebody gives me money, I'm probably going to use that to make the game and not to create a litigious act against another person. But luckily for us, you were able to step up and help us, and the GoFundMe thing went is still going pretty well, which keeps us kind of outside of the attack surface of that particular issue. Hopefully going forward, we've had a few conversations with people who've heard our story and who want to potentially help us figure out a way to get stabilized again. So we're kind of working toward that. We're kind of just perched at this point, ready to rock. We've got our art team kind of standing by. We've got Arcade High, who's made the music for Star Mazer DSP. They are in talks with us about potentially reinvigorating the Star Mazer proper soundtrack with our contract guest composers as well. I've talked to numerous of our guest composers, and those who I've been able to have contact with are all, of course, still part of our game. There's no issue there. It's just been drug out. Timelines have changed a lot. Hopefully this month we're going to make, maybe early next month, but hopefully this month we can make a realistic Kickstarter update. I have been unwilling to do so and take fully the blame. If any of our Kickstarter backers are watching right now, I apologize for having not made an update. I've actually been reticent to do so and have actually withheld update suggestions from Lindsay and from others on the team, specifically because until right now, when everything is kind of blown up and is on the internet, everybody knows kind of some large chunk of everything. It was very hard for me to say, hey guys, thanks for reading this update. I'm sorry, there's been no movement. One major component of our team has decided we're the worst human beings on the planet and literally has threatened their lives. So that's like,
yeah, it's kind of hard to talk about that.
And then how do you
that way?
How do you reach things like potential health issues or other very human, very hot button issues that really aren't part of us making a game? Somebody having an issue with us and leaving our team and trying to create, as publicly stated, as much damage as humanly possible. That, of course, interrupts and destroys the flow of a game. But really, the personal elements that have anything to do with that don't. And knowing that was kind of our burden the whole time was really difficult. And I definitely didn't want to be dishonest. I know that it was a poor choice. We've been told numerous times by Kickstarter backers that it was probably the wrong choice to be semi-silent. I mean, if you look at our comment section, I have said things trying to like let people know, hey, we're not just walking away from the game. Like, we're really trying to make it work, but there's a major problem here. But I do believe that since, not by our doing, more information than I think we would have been comfortable kind of throwing out there about people's personal states or whatever has made it to the internet, and everybody kind of knows. I think we now have a way to say, hey, okay, you guys all heard about this crazy stuff, and I wanted to wrap it up and tell you some stuff happened, and now it's better. But we can kind of say, I think we can kind of say now, hey, that there's been a big issue. We're working around it. We have no intention of stopping. Star Mazer's coming out. We're doing our best to make it happen. This is the progress, the slow but still visible progress we've made. Here are the steps we're taking to ensure that we can continue our development cycle. But again, I apologize pretty openly to our Kickstarter backers for not having done that. And I do feel it's for every person who wakes up and goes to work or does whatever, and then it pings in their brain, oh my God, I threw money at this video game and it's not out yet. I wonder what's going on. For every person who has that thought, there's me waking up every morning knowing that today I can't make progress, or today I have to respond to some sort of attack, or today I've got to figure out how to make money appear out of the air to get our art team started again. And it's just been a real... it's been a banger of a year. It's been really difficult. I try to project myself as very fun and loving and kind, and that's why I've stopped streaming, and that's why I've stopped being very social, is because I tend to be very open and happy, and I don't want to be lying.
Oh yeah, so, don't I know it? You can't stream when you're upset or unhappy or anxious. So yeah, I completely understand that. So I'm gonna kick you off my stream now.
All right.
And,
thanks for having us.
Thank you very much for joining me. And we're going to get to some of the legal documents. We're going to go over things, some things quickly, and then we'll get to the bigger updates at the end, and then we'll play some Star Mazer DSP.
Yeah, good.
DSP.
So check it out. If you do play that Star Mazer DSP, in the Discord somewhere, I know that we posted a demo soundtrack to the first chunk of Star Mazer DSP by Arcade High. It's a really good listen, so if you're into music, that's a really good thing. We just released Song 10 demo this week, and it was really, really cool. I've been doing nothing but kind of listening to it. I've been listening to nothing but that most of the week. It's been really great. So you can kind of see where we're going with the new sound of Star Mazer DSP. And if we stick with Arcade High, which it very much seems like we might, you can see kind of the flow into Star Mazer from there. So if you guys like that, please check out Star Mazer DSP on Steam Early Access right now. Every purchase you make does help us out, of course. If you've already got it, buy it for a friend. If your friend already has it, buy it for a friend's mom. If your friend's mom already has it, buy it for your friend's mom's dog. Dogs love DSP. It's got a cat admiral in it, so you should check it out.
So maybe other cats would like it.
Other cats might like it, yeah. Check it out. So yeah, that's that. You can follow me on Twitter as SkinnyTie. That's SkinnyTie. You can also follow Imagos Softworks. If you're into film stuff, you can follow Imagos Films. We have done a few things in the time since this started, and months last year ago and now, to kind of stay afloat, to pay rent and whatever. Notable things like the Devolver E3 press conference was a thing we did. You produced that. I wrote and directed that. We just did a Serious Sam's Bogus Journey live action trailer.
Bogus Detour.
Bogus Detour. Bogus Journey is Bill and Ted's movie. Oh man.
That's the joke, I think.
I think that is the joke. Then we're also this week we're shooting. If you keep an eye on Imagos Films Twitter, that's at Imagos Films. You'll see that we're shooting something next week in 1972 Milan, Italy, which is actually a Chinese restaurant.
I mean, we're not actually going.
Yeah,
to
we're going to
Italy.
turn a Chinese restaurant into 1972 Milan, Italy. Well, actually, more specifically, a bathroom in 1972 Milan, Italy, that we will fill with blood. So it'll be very cool. We'll check that out. Thanks for having us on your show, Leonard. Please keep going and stay vigilant. And I can tell you that any smiles that you're seeing are primarily due to her, but secondarily due to you and your hard work. So thank you very much.
And I want to say thank you to the community as well.
Oh, yeah,
because
yes.
I've just seen in the live chat, you guys have already been talking about how a bunch of you are going to buy DSP if you haven't already, and you've told us that you've already bought it, and that is a huge deal for us. Thank you. That just gets us one step closer to getting things back on track. So that and the GoFundMe, like you guys jumping on the GoFundMe was amazing.
Yeah.
And Leonard's amazing, and the whole community is amazing. Everybody's been really awesome.
I have to be the worst client ever. I wake up every morning and the first thing I do is like grab my phone. My eyes aren't even open. I open my eyes and I text Leonard like, "How are things?"
I think you talked to Leonard before you talked to me in the morning.
Yeah, that happens most of the mornings.
I'm fine with that.
Thank goodness there's a 3-hour time difference in my favor.
Yeah, you're well awake. And I'd also like to thank the community, also your specific community, Leonard. Your peeps are super legit and have super welcomed us and everybody, honestly, who's popped into the chat server with open arms. And I have, for the first time, in all honesty, I'd been sort of insular for nearly a year about this, and I wasn't able to really talk to people, and the people I did talk to weren't getting a lot of information from any side, and it was just very hard. So stepping into a room full of people who were interested in facts and making discussion and argument and good, healthy discussion about a real life situation that we had to unfortunately be part of it getting larger than just us. Knowing that there are people out there who are interested in making things right is pretty great, and it's been it was the first eye opener to me that there are people out there who like I have this weird hang up like if I've done something to the best of my ability and somebody says you've done it wrong, I think my first instinct is to say, oh man, I must have really done it wrong and not known. How can I do it better and what can I do to fix it? And in this particular situation, it's a compound like pile of hundreds, if not thousands of those things. And every single one of them I question, and every single one of them I doubt, and every single one of them I try to make sure, am I really doing the right thing? Was this offer right? Was this choice right? Did I say the wrong thing here and there? And it kind of weighs on me like this giant, 20 billion ton load. And to hear at least parts of those things be disseminated, even without people knowing I'm reading or whatever, to see little bits of those things be kind of like picked apart and turned into, actually, I believe Imagos may have made the right step here, and that kind of removes some of the weight. I'm sure the whole thing won't go away until everything's over with, if it can be over with. But knowing that there are objective people who are not connected to me in any way with an opinion, not inspired by something I've said directly at their faces, that is really good. And I'm not even saying opinions that favor our position or anything, just knowing that there's a discussion and there's a reality. This thing exists not just as a nightmare for me and for my company.
You
and
have
for my
support.
team.
People love you, and people love the game, and they want to see more of what you and your team and Lindsay and everybody has to produce and offer, because the game is awesome. It's funny. It's snarky. It's sarcastic. It's great. It's got character. It's got heart, and it's hard. And I hate you for that, but it's okay.
Well, luckily, Star Mazer proper isn't going to be as hard as Star Mazer DSP. It's going to be a much more story-based experience. But DSP will
kick your butt.
Yeah, it will. Yeah. It will accept your apologies.
And I don't think you should change that at all.
I'm
just complaining.
Have you beaten Act 1, Leonard?
I did beat Act 1, but it took a lot of trying. I think I'm like 8 or 9 hours into it to get Act 1 beaten.
Good job.
There are 2 full acts coming at your face. The second act is partially done and available in early access for those of you who don't have it yet. And Act 3 hasn't been produced or hasn't been pushed to early access yet, but we're getting there. Especially now that it's back online, we can see ourselves making very clear progress along with Pixel Jam. Pixel Jam can spin up again and get working on it. There was a time where our situation with Pixel Jam was a bit tenuous. Pixel Jam being our partner developers who do all the code for that game, since all of our time is spent doing Star Mazer. Or has been spent doing Star Mazer. Recently, it's been spent trying to not lose our company and go into a tiny pit of depression from which we will never recover.
All right.
That said, Star Mazer DSP can be kind of spun back up now that there's clear evidence that it's a viable product that people want and things are going. So
great.
Enjoy it. I hope you guys enjoy it.
Excellent. Yeah. You guys have a great evening, and I'll talk to you, soon, I'm sure.
Thanks, guys. Thanks for watching.
Thank you.
Thanks for joining.
Bye.
Yep, that's not it. There we go. Now I'll hang up. There we go. All right. Close that down. All right, everybody. Welcome back. Sorry that's so awkward. The technical issues, I mean. That's my fault. We're trying to get everything, I've only got so much time. So, what are we going to go over tonight? I have a whole agenda. I'll pull it up on my big screen here and put Brandon on my other screen so he can tell me when I'm doing something wrong. And I don't know. I don't have another screen for the YouTube chat, so I'll just put that someplace too. So, we are here to talk about mostly this order that we got last week, but also everything kind of from the beginning. Does that go in the, hey, that goes in the corner, and then there's the chat. Hey, this works out beautifully. Okay. Okay, so if you're not familiar with why we're here and what Don was just talking about and all that, there was a person, I'm going to refer to this person as defendant as much as possible. You can find defendant's name on the documents and things if you really care, but I'm kind of done giving defendant any attention, so I thought maybe we should just refer to this person as defendant. So if you're not familiar, a person who used to work for those two people who were just on the stream, Don Thacker and Lindsay Peck, I think is her name. Lindsay is one of the producers, or the producer, and Don is the kind of the owner or CEO or operator person for, it's their creative thing. And the point is that defendant is working for them and doing the music for the game Star Mazer DSP and Star Mazer proper that we're discussing here today. And this person, defendant, sent multiple DMCA takedown notices out of the blue, taking down the game, taking down people's videos about the game, taking down people's videos about the situation, taking down people's videos about defendant. It was all a very big thing that was happening about this time last month. I responded by making a video about it. I think it might have even been a live stream video like one of these. And that got the attention of many potential claimants or plaintiffs, not the least of which is our plaintiff here at issue, Imagos Films and Softworks and Don Thacker. So we filed a complaint. I'm going to refer to the first amended complaint. We actually filed a complaint about a week earlier, but this contains some important fixes like correcting defendant's name, which was very important to defendant. In order to be able to file this complaint, you guys came together and I started a GoFundMe on behalf of my client, and you guys funded that to the tune of about $10,000 to $15,000 within about 36 hours, which was absolutely amazing. The problem was, along the way, the defendant was getting more and more, the defendant's behavior was becoming more and more interesting. And I really don't want to call any more attention to it, but her behavior became very threatening. And so the case became not just about the DMCA takedown notices and the underlying dispute there, but then about these threats that literally I was receiving firsthand. So with the community coming together and giving us the funds that we needed to start a lawsuit, I wrote an amended complaint. Or I wrote a complaint. This is the amended complaint, but I wrote a complaint explaining that the basic background here, that defendant had worked for Imagos, and when you work under that kind of arrangement, your copyrights belong to the larger commissioning organization. I made out the allegations for all of the things that we needed to make out. And the important part is that I charged her with, or I claimed in my counts, copyright misrepresentation, breach of contract, defamation, and some kind of extortion or blackmail for using the DMCA takedowns to threaten people to voluntarily take things down rather than being subjected to a DMCA takedown. So I filed this complaint on June 30th, served her within the next week, filed this amended complaint to correct her name, and then had to decide what to do next. So what would you do next? You filed a complaint. The defendant has 21 whole days to respond, if service is even good, but your video game is down, and so what do? Well, there's actually something that the law does allow you to do to get even faster or expedited relief. You could make a motion for expedited something or other, but defendant has only been served, has not responded to the complaint, so that's really not a thing. So there actually is a federal rule of civil procedure called Rule 65 that allows you to file for some kind of injunction. The injunction could be in the form of a preliminary injunction, or it could be in the form of a temporary restraining order. They are very, very, very much similar, almost the same. The wording is slightly different. We call a temporary restraining order that's one of them, and preliminary injunction is another, and they're actually two different things. Basically, the temporary restraining order or preliminary injunction is a way to ask a judge to give a plaintiff relief now, or claimant. It doesn't have to be a plaintiff, but on application by a party, the judge will usually schedule a hearing within 48 hours, and if you can show the elements of that are required for the restraining order, there's a chance the judge will grant it. Well, restraining orders are exceedingly rare, especially after I got mine. I actually asked around to see how often does this happen, and found out that no one even knows what it is. Most people, when they hear restraining order, they think of a domestic relations restraining order or protection from abuse order for protection from a person who's usually in your family or in your community who's trying to hurt you or who already has hurt you. This is not quite the same. It could certainly be used for that, but this includes any relief that is cognizable under the law, any remedy that a judge can grant. As long as it's appropriate. And so what I had to show in my application for a restraining order was a few things. I had to show that I was likely to win when we were at trial. I had to show that the defendant was not going to suffer any terrible prejudice or burden from my getting this order. I had to show need for the order in the form of irreparable injury. The law requires you to show an injury that cannot be remedied at law, and so if you're going to suffer some injury that cannot be remedied, then you have good cause to show a judge, I need a temporary restraining order in order to avoid this irreparable injury. So I filed an application for said temporary restraining order on the 11th of July, about 10 days ago. In the restraining order, I asked the judge to halt defendant's false claims of ownership to plaintiff's works. I did ask the judge to also halt the claims to works created by third parties. The defendant's let me see here. The where is my the order I was looking for must be further down in the list here. But I asked the judge for a restraining order that halts her from making further threatening statements, halts her from sending further DMCA takedown notices, and requires her to provide us with a list of any takedowns that are outstanding, and requiring her to not make any further claims. And what the judge actually granted was that a very similar restraining order. But let's just go over this here for a moment. Whenever you file a restraining order, you have to file a brief along with it, and the brief has to show certain things. So here is my table of contents, and it's a very simple temporary restraining order application because it's actually, in my humble opinion, not that complicated of a case. Someone has made a claim to a copyright. This copyright doesn't belong to them, and so we're just going to show who owns the copyright. It really cannot be this difficult, right? So, very simple introduction that I'm going to skip and get straight into, well, I guess we can go over this. Plaintiffs Imagos and Don Thacker bring this action to halt defendants falsely claiming ownership to plaintiffs' copyrighted works. Defendant has filed numerous false Digital Millennium Copyright Act takedown notices both directly against plaintiff's video game franchise Star Mazer, but also against works by plaintiff's customers in the form of a review or a Let's Play video. Defendants' false copyright claims have resulted in plaintiffs' works being removed from sale on the Steam Game Store, one of the largest online video game sales platforms, no less during the Steam Summer Sale, resulting in hundreds of thousands of dollars in lost sales. Defendant boasts about being judgment-proof and the effectiveness of her false claims. Defendant claims to be motivated by an alleged contract dispute with plaintiff over a relatively small amount of money. Yet defendant has refused to resolve the contract dispute through the courts, instead choosing to issue copyright takedown notices in coercion of plaintiffs and its customers. So I continue to go along here explaining how this is a violation of DMCA 512F, going through the facts of how defendant was contracted in March of 2015 and stayed on until sometime in late 2016 where she voluntarily left, that she was paid $36,500 of the $40,000 that was due under her contract, etc., etc. If you have been following this story, you've heard a lot of this already, which is why I haven't been trying to go into great detail on all of this. Also because I want to get to some of the hotter documents in this analysis here. So you have to justify your request for a TRO with a claim that you will suffer a severe and irreparable injury. In this case, it's pretty easy to show that this is an irreparable injury. The entire game is taken off of Steam and can't be played by new people, can't be purchased by new people, can't be gifted, really can't even be seen, and so there's what question is there? There's sales are down. People who are involved with development can't work. People who are involved with financing don't want to pay money because there's no product being made. So it was pretty easy to justify the need for the TRO. And so, very interestingly, I mentioned this TRO to the judge's clerk and was immediately granted a hearing less than 48 hours later. Then I served the defendant with a copy of the TRO application and advised that she get an attorney. And I was extremely surprised to find that she did. And so I received this letter on July 12th. Dear Judge Schiller, I was just retained. Here, let me, that'll help. I was just retained this late evening to represent the defendant in the TRO hearing scheduled for 11 a.m. July 13th. I am writing to request a 1-week continuance. I spoke with Mr. French this evening, but he refused to consent to my continuance. Yeah, no shit. My client agrees not to file any further copyright takedown notices until the hearing takes place. She will also not take any further affirmative action on any already filed takedown notices. Also, just to address plaintiff's allegations on which we disagree, my client will not make any threats or take any physical action against plaintiffs or their attorney. Plaintiffs will not be prejudiced by this proposed short delay. Well, wouldn't you know it, I wasn't sure whether the judge would grant this continuance request or not, so I got in my car and I drove to Philadelphia on Thursday morning, and I was about halfway there when the judge called to say that we were on, and the judge was not going to grant a continuance, and we were going to have the hearing. So I showed up to the courthouse about 10:30. I did not attempt to locate defendant or anything other than making sure that defendant wasn't attacking me with anything. And I sat down and tried to cool myself off. It was a very hot summer day, and just waited. The judge's courtroom was empty, and only a few minutes before the hearing did there start to be activity in the room, and with the judge's staff coming out and things. Eventually, the defendant showed up with her attorney. We had the hearing, and the hearing only lasted a few minutes. The judge asked why the temporary restraining order should not be granted as agreed, maybe not as I wrote it, but maybe as the defendant already seems to have agreed not to send any more threats, not to make any more takedown notices, and not to take any action on existing takedown notices. The judge said that, hey, I should just be able to grant that, right? You've already agreed. Well, there was an objection that the defendant had already agreed to it, so why would there have to be in the form of a TRO? Well, the whole point of this was if we have a court order from a federal judge, then if that order is violated, that puts defendant, or whoever violates the order, into the judge's contempt powers. And the judge's contempt powers are virtually unlimited. The words are at the discretion of the court. You can be fined, you can be imprisoned, all based on the order. So I explained to the judge, because I have to, the judge turns to me and just wants to hear what I have to say. The judge is not going to do my job for me. Okay, plaintiff, what's wrong with agreeing that she's not going to send anything instead of issuing a TRO? And I explained that I really wanted defendant to be within the judge's contempt powers discretion, that if she violates, the judge can take the appropriate action. And the judge agreed. And the hearing was only about 5 minutes long. It was one of the fastest hearings I've ever been in, and we got the following order out of it. And now this 13th day of July 2017, following a conference regarding plaintiff's application for a temporary restraining order, it is ordered that defendant shall not issue further copyright claims or takedown notices, including Digital Millennium Copyright Act takedown notices, for any work relating to Mazer. Defendant shall take the necessary steps to rescind the takedown notices currently pending for any work relating to Mazer. Defendant shall refrain from making threats of physical harm or violence and physical harm against plaintiff or plaintiff's lawyer. Plaintiff shall post bond in the amount of $100, and the court will conduct a further hearing on Wednesday, July 19th. So now, why would the court conduct a further hearing? Well, this was all based on Attorney Mazzio's application for a continuance. If he needs a continuance to prepare, well then great. Then we'll have the week that he asked for. He'll be prepared. We'll come in next week ready to fight it out over the temporary restraining order. Well, that would have been kind of nice if things worked out that way. I would have loved to have been fighting this case against a fellow member of the bar. However, things did not work out that way. You can follow the drama if you want, but I'm going to attempt not to call attention to the drama. But within half an hour or so of the first TRO hearing, the defendant had allegedly, seemingly fired her attorney or attempted to fire her attorney. And I wasn't entirely sure if that's what had really happened or if that was just a dramatic story and I would still hear from an attorney in court the next week. And then the following day, I got this. Yes, this says 17th. This is an amended motion to withdraw. It has additional stuff in it. Attorney Mazzeo filed an original motion to withdraw. No, I don't want to redact that. Thank you very much. Why am I in redaction mode? Attorney Mazzeo filed an original motion to withdraw on July 14th, and and he amended it on the 17th. So here is the amended version. Attorneys of record for defendant file this amended motion to withdraw their appearance as attorneys for defendant. Defendant terminated the attorneys. By this amendment, the attorneys provide additional reasons for the request to withdraw, mostly because a defendant refuses to speak to her attorney, and she said she would refuse to attend the July 19th hearing if he were to attend, as it has become nearly impossible for Attorney Mazzeo to properly prepare for the scheduled July 19th, TRO hearing, or to represent defendant. Attorney Mazzeo also hereby requests a continuance of that hearing so that a defendant can obtain new counsel. So he filed this motion to withdraw as well as a brief here explaining everything pretty much that I've gone over so far. Then he explains, the Pennsylvania rules of professional conduct are relevant in the court's determination of whether to allow withdrawal. The Pennsylvania Rules of Professional Conduct 116 in relevant part provides, a lawyer shall not represent a client where representation has commenced and shall withdraw from the representation if the lawyer has been discharged. And so, of course, that's a very appropriate thing to do. Withdrawal is appropriate and, in fact, mandatory under PRPC, Pennsylvania Rule of Professional Conduct 116A3, because they have been expressly discharged. Maurer told Attorney Mazzeo via text message that he and Mazzeo and his firm were terminated following the TRO hearing. She sent a letter to the court restating and confirming her discharge of Attorney Mazzeo, specifically stating in the letter that Mr. Mazzeo is fired and needs to formally withdraw from the case. Defendant sent a photograph of this letter to Attorney Mazzeo via email, which is attached. Understanding himself and his firm to have been discharged, they sent a letter reporting the deadline for her to answer or respond to the complaint. The attorney is obviously doing his very best job to cover his butt and make sure that he's allowed to withdraw from this case. And then he gives some additional reasons here. That a defendant has been contacting me, opposing counsel, directly in violation of the rules of professional conduct if he is her attorney. And that's also something that an attorney wouldn't want to represent if his or her client is going around them. He cites that defendant has refused to follow his reasonable advice, that she has left multiple phone messages, and that he will provide more information in camera, which means in person, to the judge. So eventually this motion to withdraw was granted, and Attorney Mazzeo was let out of the case on the 17th, very shortly after this motion was filed. So then, there was yet another hearing. We had the hearing on the 19th at 9 a.m., I think it was 9 a.m. Was it 9 a.m. or 9:30? I think it was 9:30 a.m. And I attended. And this time it was just supposed to be myself and the defendant. And so I was not expecting there to be an attorney, but of course there could be anybody who, she could find an attorney at any moment and show up to court with that. But instead, what happened was she appeared with her father, and we all spoke to the judge. It was another very short hearing. There didn't seem to be a lot to contest about the temporary restraining order, which was the entire point of us being there. And instead, the point of the hearing seemed to revolve around defendant not knowing how to respond to all of the filings that I've made, and instead wanting more time to get an attorney. So, out of the July 19th hearing, we get this order. And now this 19th day of July 2017, it is ordered that defendant shall have until Monday, August 21st, 2017, to locate an attorney to represent her. And defendant shall file an answer to plaintiff's complaint on or before Monday, September 25th. So this is kind of different. This is kind of odd. Why would the judge give her so much time? That's 30 days or more to get an attorney, and that's another 35 days or more to then respond to the complaint. Normally, a defendant has 21 days to respond, so heck, I served her on the 30th of June, so this is the 21st day, so we should be done, right? I should be able to file a motion for summary judgment, and we should, a motion for a default judgment, and we should just be done and over with right now. No, unfortunately, that's not the way it works. The judge wants to give her a chance to get an attorney and make her case. Why would the judge want to let her do that? Well, there's a few reasons. One, the judge may anticipate some of the same things that I anticipate. She will either have trouble finding an attorney, or she will willfully not find an attorney, or she will find an attorney, but that attorney will be telling her, hey, wait, this is not a good case. You should settle this case or find a way to get rid of this case because you don't own these copyrights. And this extra time should allow the judge to say, hey, what's the problem? We gave you all this time. If you didn't get it done in this extra time, then we're going to really shut you down. So it could be the judge trying to give both parties the space to, one, on Alex and defendants and getting the attorney that she might need or getting the assistance that she might need there, and two, kind of covering plaintiff's butt from any defendant's appeal if defendant loses because she didn't get an attorney. So, yeah, we're just going to wait and see what happens there. In the meantime, this is actually kind of a blessing in disguise for plaintiff because this also gives me plenty of time, pretty much all the way up until even the end of August, to make a motion or request to the judge to amend the complaint and add further clarification to our claims, add additional claims, clear up exactly what I mean by the coercion, blackmail, extortion claim, maybe add an intentional interference with a contract claim and some other things. I think there's a tortious interference with a contract claim that I can add, that I want to put in there. So this is not necessarily a good thing for defendant to be given this amount of time. It just means that we have even more time to bring further claims against her and further refine our case. Let me see what else. So what happens next? Oh yeah, there was definitely something I wanted to go over. Let me pull up this one case. What happens next is I get to write a little bit more of a brief. I get to do a little bit more legal research and reinforce our case as much as possible so that when defendant inevitably comes back to court and tries to make a case or a claim, that I'm prepared. Oh, I didn't want this one. Hang on. I wanted a different one. Perfect. It just so happens that this week there was a decision in a completely separate case under slightly different circumstances, but some of the circumstances really overlap, and so I thought I would take a few minutes here. I know it's 14 pages. We're going to try to go quick, but this really is worth a look. This is Judge Brian Cogan, I think his name is, in the Eastern District of New York, which is Brooklyn. And this is the case of Ian Schleifer against Kitty Behrens. And this is what I'm going to refer to as the copyright cookbook case. Excuse me. Oh, we have a dog. Plaintiff brings this copyright infringement action alleging that defendant's Ethiopian cookbook violates the copyright that plaintiff has on his own previously published Ethiopian cookbook. Before me is defendant's motion to dismiss the amended complaint pursuant to 12b-6, as well as her motion for attorney's fees and sanctions. For the reasons that follow, defendant's motion is granted. Moreover, because plaintiff's complaint has no legal or factual basis, defendant's motions for attorney's fees under the Copyright Act and for sanctions against plaintiff's attorneys are granted. Let me tell you, this is not someplace you want to be as a plaintiff's attorney if you're on the other end of this case. Plaintiff Schleifer published his Ethiopian cookbook under the pen name Ian Finn in 2007. The 2007 work included 17 pages of written content, including 11 recipes, 3 pages of photographs, total 20 pages. 2 versions of the book, one on Amazon, had more pages, etc. Defendant published her cookbook in 2015 under the pen name Kitty Behrens. The Behrens cookbook contains 185 pages, 140 recipes, commentary, instructions, descriptions, and shopping guides. Also includes black and white, color, and monochrome illustrations. In 2016, plaintiff published a second edition. The second edition bears the same name as the 2007 Schleifer cookbook and itself identified by the second edition on its title. Same kind of thing. It has 12 recipes and several black and white photographs, 82 pages. Notwithstanding the differences in pages and numbers of recipes, plaintiff alleges that there are no substantive differences between the 2007 and 2016 cookbooks, that all infringements and copied text can be found in both editions. Plaintiff argues that both the cookbooks are identical in content, notwithstanding certain grammatical updates. Plaintiff alleges that based on defendant's responses to interview questions in which she stated that she read a lot of recipes and books as part of her research, one can infer that defendant was familiar with plaintiff's cookbook. Discussion. Motion to dismiss standard of review. In deciding a motion to dismiss under 12b-6, a court should draw all reasonable inferences in plaintiff's favor, assuming all well-pled factual allegations to be true, and determine whether they plausibly give rise to an entitlement to relief. Why do we do this? So it's a motion to dismiss, which means defendant is filing a motion to dismiss. Plaintiff can't file a motion to dismiss. So a defendant is filing a motion to dismiss under Federal Rule of Civil Procedure 12. And when you do that, this is the standard that applies. That you draw all reasonable inferences in plaintiff's favor, assuming that all well-pled factual allegations are true, and determine whether all of that gives rise to an entitlement of relief. A court is not, however, bound to accept conclusory allegations or legal conclusions masquerading as factual conclusions. Thus, threadbare recitals of the elements of a cause of action supported by merely conclusory statements do not suffice. Although legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. Determining whether a complaint plausibly states a claim for relief is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. In addition to the text of the complaint, the court may consider documents attached as exhibits, etc., etc. In a copyright infringement action, the works themselves supersede and control any contrary descriptions that the parties offer in the pleadings, sort of also known as the best evidence rule. B. Copyright infringement. To state a claim for copyright infringement, a plaintiff must allege 1. Ownership of a valid copyright, and 2. Copying of constituent elements of the work that are original. In the absence of direct infringement, In the absence of direct evidence, copying is proven by showing that a defendant had access to the copyrighted work and showing the substantial similarity of protected material in the two works. Not all copying constitutes copyright infringement. Yes, we know all about fair use. As the Second Circuit has repeatedly stated, it is an axiom of copyright law that the protection granted a copyrightable work extends only to the particular expression of an idea and never to the idea itself. Furthermore, simply because a work is copyrighted does not mean every element of that work is protected. Therefore, dismissal is appropriate where the similarity concerns only non-copyrightable elements of plaintiff's work, or if no reasonable fact finder could find the works substantially similar. District courts may evaluate substantial similarity at the pleading stage on a motion to dismiss, etc., etc. The standard test for substantial similarity between two items is whether an ordinary observer, unless he set out to detect the disparities, would be disposed to overlook them and regard the aesthetic appeal as the same. However, a more refined analysis is required where the allegedly copied work is not wholly original, but rather incorporates elements from the public domain, in which case a court must look for substantial similarity between those elements and only those elements that provide copyrightability to the allegedly infringed work. The Second Circuit has called this latter test the more discerning test, and in applying it, the Circuit has cautioned courts not to dissect the works at issue into separate components and compare only the copyrightable elements, but rather to be guided by comparing the total concept and feel of the contested works. More specifically, a court must examine the similarities in such aspects as the total concept and feel, theme, characters, plot, sequence, pace, and setting of the works, while taking care to inquire only about the protectable elements standing alone and whether they're substantially similar. I'm going to skip a little bit here. Although there is an issue as to whether plaintiff secured his copyright registration, even if a court accepts that he had a valid copyright in 2007, plaintiff has failed to establish substantial similarities between the 2007 Schleifer cookbook and the Behrens cookbook. The below table compares the infringing material that plaintiff identifies in his amended complaint and the corresponding content in the Behrens cookbook in blue italics. And here the judge is showing us these overlapping words. The plaintiff's cookbook says, using our spongy crepe-like injera bread, soaked through with the flavors and colors of the food. And then the Behrens cookbook, injera, a spongy, tangy, crepe-like bread that soaks up the yummy sauces from the food. Tibbs, this is a vegetarian spin on a popular meat dish. Tibbs is similar to a sauté, stir-fry, or sizzle. And then Tibbs are traditionally meat-filled stir-fry dishes, etc., etc. The words that overlap don't seem to be very copyrightable. These few common words provide no basis for a copyright infringement claim. First, the factual content describing particular Ethiopian foods, ingredients, or culinary traditions is not protectable as a matter of law. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. To the extent that the two works have general similarities, including the fact that both are about vegetarian or vegan Ethiopian cuisine, the inclusion of illustrations of prepared dishes and descriptions of foods as spicy, spongy, or the like, these elements simply do not amount to a claim for copyright violation. Instead, they are scène faire, or unprotectable elements that follow naturally from the work's theme rather than from the author's creativity. Plaintiff's alleged similarities with respect to the individual elements outlined above are insufficient to sustain his contention that the cookbooks are substantially similar within the meaning of copyright law. Just as the court found in another case, the similarities identified by plaintiffs are the result of the similar medium of expression used, cookbooks, or of the similar subject matter that the cookbooks address, Ethiopian food. Stock elements resulting from the initial choice of subject matter are not protectable. The Seinfeld court further observed that when a cookbook is based on a particular idea or theme, Whether it be a vegetarian cooking, grilling, or desserts, the individual recipes in that book are certain to share that common theme and will likely share certain similarities with recipes in other cookbooks based on the same idea. Moreover, even the most belabored analysis of plaintiff's allegation shows the complaint rests on scattered words and short phrases, neither of which are protectable. Hang on, there we go. Yeah, there we go. Didn't explode. Whoa. Words and short phrases rarely, if ever, exhibit sufficient originality to warrant copyright protection. I thus reject plaintiff's argument that his content is original expression to engage the mind as to the flavors, textures, methods, and practice of the art of Ethiopian cuisine. His cookbook is no such thing. His attempt to claim infringement based on scattered phrases necessary to explain the common theme of vegetarian or vegan Ethiopian cuisine fails. Pardon me. As to plaintiff's generic assertion of substantial similarities, numerous differences tend to undercut substantial similarity. And I'm going to assume that there are lots of them. Although the compilation of non-protectable facts is copyrightable if it features an original selection or arrangement of facts so that the selection or arrangement possesses at least some minimal degree of creativity, that is not the case here. Even if the court were to consider the longer Amazon cookbook in conducting its comparison, the 2007 Amazon cookbook and Behrens cookbook are substantially dissimilar, etc., etc., etc. I am going to skip ahead to this part because this is the epic part that I'm sure certain plaintiffs in another case might want to hear. The assessment of attorney's fees and costs against plaintiff and his counsel under the Copyright Act and pursuant to the court's inherent authority. This is why you might not see another attorney get involved in the case, because of this standard right here. Under the Copyright Act, a court in its discretion may allow the recovery of full costs and also an award of reasonable attorney's fees to the prevailing party in a civil action for copyright infringement under Section 505. Important here is that costs and attorney's fees are equally available to a prevailing plaintiff or a prevailing defendant. An award of attorney's fees and costs is not automatic, rather the district court has sole and broad discretion to determine whether such an assessment would be fair. When determining whether an award of attorney's fees is fair, district courts may consider such factors such as the frivolousness of the non-prevailing party's claims or defenses, the party's motivation, whether the claims or defenses were objectively unreasonable, compensation, and deterrence. The third factor, objective unreasonableness, should be given substantial weight. Additionally, as the Supreme Court recently noted, 505 costs and fees should be awarded in such a way that, encourages parties with strong legal positions to stand on their rights and deter those with weak ones from proceeding with litigation. Accordingly, the court should give substantial weight to the reasonableness of a losing party's position. The court also has the inherent power to impose monetary sanctions on a litigant or his counsel, including the assessment of attorney's fees and costs. Under this inherent power, a court may assess attorney's fees when a party or lawyer has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. Here, an award of attorney's fees and costs under the Copyright Act is warranted because the factual and legal contentions plaintiff argued were either frivolous or objectively unreasonable, and there is a need in this case for both compensation and deterrence. First, the unreasonable nature of plaintiff's claim in this case is manifest. It was objectively unreasonable for plaintiff to have believed that a colorable copyright action exists based on 4 examples of similar language in what amounts to a non-protectable factual description of Ethiopian cuisine and culinary tradition. The unreasonableness of plaintiff's position is supported by the fact that plaintiff's opposition to the motion to dismiss contains a mere 3 1/2 pages arguing that his copyright claim was actionable. The vast majority of those pages is the plain recitation of the legal standards, which is to say that plaintiff could not point to any cases that would support his actions because there are none. Put differently, plaintiff's position was so far afield that his attorneys could not even defend against the motion to dismiss. The objective unreasonableness is compounded by the unreasonable manner in which the case has been litigated, from plaintiff's failure to properly investigate defendant's publisher's letter explaining why his claim lacked merits and the legal arguments, to his infringement allegations regarding content not actually contained in the 2007 cookbook, but rather contained in the 2016 cookbook, to the inclusion of unsupported infringement allegations in the amended complaint that nowhere appear in the 2007 cookbook, to the bald assertion that the 20-page 2007 cookbook is identical to the 82-page 2016 cookbook. These allegations greatly exceed the bounds of fair argument. Plaintiff argues that he wholeheartedly believes this lawsuit has merit and is not made in bad faith, but that, even if true, is immaterial. The standard is objective reasonableness, not subjective reasonableness. More fundamentally, a layperson's wholehearted beliefs do not save him or his attorneys from having to pay fees. It was incumbent on his attorneys to explain that his copyright action was frivolous, and their failure to do that, and several other failings, leads into why the court will exercise its inherent authority to sanction plaintiff's lawyers for attorneys' fees and costs. No reasonable copyright attorney, or even an attorney who had devoted 20 minutes to legal research, would have filed this complaint. If plaintiff's attorneys did not do the requisite research when filing the complaint, surely they should have recognized the absence of merit when preparing the opposition to the motion to dismiss. Despite seeing no supporting case law, plaintiff's attorneys forged onward. Worse than that, I cannot comprehend how plaintiff sought statutory damages when he had no copyright registration at the time that defendant published her book. It is axiomatic that statutory damages are only permitted when a plaintiff has a valid registration at the time of infringement, and that here plaintiff did not register his 2007 cookbook until 8 months ago. Such steadfast adherence to an untenable legal position and the submission of false allegations and far-fetched arguments to this court rise to a level of bad faith that compels the imposition of attorney's fees on both plaintiff and his attorneys. Here, the award of costs and fees to defendant furthers the goals of the Supreme Court. This is New York Supreme Court. Oh wait, well, I guess it's also the Supreme Court of the U.S. and courts in this circuit, and have repeatedly emphasized in copyright cases compensation and deterrence. When plaintiff filed this frivolous action, defendant had no choice but to engage counsel and expend resources to litigate this case. Under these circumstances, the policies behind the Copyright Act would be violated if this court required defendant to bear her own costs and fees. It is increasingly recognized that the person who forces another to engage counsel to vindicate or defend a right should bear the expense of such engagement and not his successful opponent. As to deterrence, an award of attorney's fees and costs is crucial here, so as to deter this plaintiff and other similarly situated plaintiffs from bringing frivolous and objectively unreasonable claims. There is also no need to deter, by my pausing there, I didn't mean our plaintiff, I meant our defendant, for having an objectively unreasonable claim. There is also a need to deter attorneys who fail to comply with their obligations to the court to research and put forth good faith claims and defenses. Therefore, the court concludes, in the exercise of its discretion, that an award of costs and attorney's fees to defendant would serve the purposes of the Copyright Act, and that such an award is necessary here. Those same reasons animate the court's assessment of sanctions on plaintiff's attorneys. Their conduct in this case can only be described as bad faith. Plaintiff's attorneys failed to perform a pre-litigation investigation and then failed to withdraw the claims when, on drafting the opposition to the motion to dismiss, they found no case supporting their position. Not only could they not affirmatively support their case, but they could not even address the majority of defendants' substantive arguments. Plaintiff's attorneys seem to have taken the position that they are going to roll the dice, even though nothing in law or fact supports their filing or prosecuting this suit. Given the foregoing, it is appropriate that both plaintiff and his attorneys be jointly and severally liable for the costs and fees for which the court will assess after submission of billing records by defendants. Accordingly, defendant is ordered to submit within 14 days, itemize costs and contemporaneous time and billing records for defending this action. Plaintiff has 14 days from the filing of those records to object, and defendant has 7 days to reply. The court need not reach defendant's argument reaching additional statutory sanctions. Yada, 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 yada. Digitally signed by Judge Brian M. Cogan. So, So defendants and plaintiffs alike should refrain from bringing or maintaining objectively unreasonable positions in their court cases, or else they will be saddled with all of the costs of the opposing side, and possibly additional sanctions. Sometimes additional sanctions are a multiplying of those fees, or things like that. So that's that. So yeah, this has all been a very interesting past month for everyone. We've learned a lot about how much the YouTube DMCA system can be abused. We've learned that the community can, in fact, come together to support an action in defense of a developer's rights. And we'll see what can be done further. If there are any YouTubers or any other claimants out there who have been affected by Alex malware who want to file actions in court, join the Imagos action or things like that, we can all talk about those things. There are some reasons why I haven't been entirely eager to join many additional plaintiffs to the lawsuit, mostly having to do with ethics and having to do with costs. So I'm more than willing to work with all of the plaintiffs. We just need to figure something out. And look, we have some time. The judge gave Alex 35 days or 30 days plus 35 days, so 65 days before anything is going to be responded to. So we have approximately 30-some days to get our, more stuff on our end done. I was going to say get our butts in gear, but my butt's been in gear for a couple weeks now, and I'm actually really kind of relieved to not have to lose sleep at night over it. Basically, I've been waking up in the middle of the night to check things like Twitter and email and stuff and see if there's been responses or if someone's Twitter account has blown up. So I'm actually really grateful that there will be a little bit of space now, and maybe I can get back to making videos that aren't on this topic for you guys and the channel and all that, and get back to a little bit more semblance of real life. So hey, I'm gonna go find a dog, and I'll be back in a second. There actually is a dog right here, so maybe I don't have to go very far. And meanwhile, I think I'm gonna have Brandon start submitting questions that he's been collecting to the staff chat. I see him, he's typing already, that's great. And maybe he'll post some things and we can do some Q&A while I pet a dog and queue up Star Mazer, and then we'll finish out the live stream with a few minutes of Star Mazer. So you're putting them in my PM. Okay, that's fine. Let me grab a dog. This dog right here. Here's a dog, and that is his happy little grunt. I hope you guys caught that on microphone, because that's his happy little grunt. How are you, honey? Okay, so Hygiene asks, when people are in legal action, they usually say that they can't comment on a case, but I comment so freely. Is that simply because you are a lawyer and you won't say anything detrimental to the case? Well, it's a very good question. Lots of people have been asking why I'm so public about the case. One is because this is somewhat damage control, public relations, trying to mitigate the damage that's been done. Defendant has been very public about what has happened, and so there are lots of questions about about whether her claims have merit or how quickly we can overcome her claims. And so court action moves only so quickly. I mean, even with the temporary restraining order you saw, it still took me 2 weeks to be able to get that from start to finish. And even if I couldn't get the TRO, there would still be, 65 more days for defendant to respond. So what's that? We're going on about 90 days. So we needed to be able to take action faster than that. So talking to you and being public about this has helped Imagos, has helped Don, has helped Star Mazer overcome the problem a little bit faster than they might have been able to. So that's why. Okay, question from Comrade Kage. I understand that this is cases between Imagos and the defendant, but I was wondering, is there any chance you could possibly be representing other parties? Yes, it is possible. As I've been looking further and further into that, it's not hard for anybody to join the case. What's difficult is for me to figure out how to handle the funds in the case. You all donated a lot of money to help Imagos's cause. So then if I join another plaintiff to it, who's paying for that? Does that person have to start a separate GoFundMe? Do we take those funds out of Imagos's funds? What if Imagos needs those funds? What if there's 10 other plaintiffs and they don't all have money? How do I decide which ones get help and which ones don't? So there's lots of questions I have that I haven't been able to answer yet. That's why I haven't been able to join a bunch of plaintiffs. Is it possible to watch the trial? I'm not sure that there's going to be a trial. I'm thinking this might not even go that far. No, usually we don't get to watch the trial on video. I'll look into whether that ever happens anywhere. All right, you're heavy and you're hot. I'm sweating. Oh, thank you. I love you. Okay, question from Matt East. So the lawsuit Leonard just read, the attorneys apparently had some liability for filing the frivolous lawsuit. Could that happen to an attorney Alex hires? Or would it be different since the attorney would be defending her instead of starting a new suit? Yes, Matt, you're on the right track. It would only be for any misbehavior that the attorney is guilty of starting from the attorney's representation. They're not responsible for Alex making the illegitimate claims or anything. However, if they don't tell her, you can't maintain these claims, then they could get in trouble as well. That's as this attorney did when they didn't stop this plaintiff from maintaining their action after the motion to dismiss was filed. Question from Delta62. Have you gotten questions from other media sources? I know according to Sid Alpha that game journalists have been poorly representing the case. There have been a few media inquiries, but not really anything from any major media outlet. I do recall there was one or two law news outlets that wanted to hear more about it, and I think they might have even gotten a little tired of me that I didn't get back to them right away. I was still working on the TRO and everything, and it's only right about now that I'm going to be ready to talk about the case, which is why we're here. Question from Poopnock. Are we going to be able to see the minutes and transcripts from the hearings? Yes and no. So here's how minutes and transcripts from hearings work. There is a court stenographer who types on their typewriter in real time, in shorthand, and bangs out everything that everybody says. Well, that person gets paid a very special wage, and the court gets reimbursed for their time a very special way. When you want that transcript, you have to pay for it, and you have to pay a per-page transcript fee, which covers the stenographer's time in producing that transcript. So that transcript may be $50 or $100 or sometimes even more for a longer transcript, depending. I personally do not need the transcript from either of the hearings that we've had. So while they exist, they're going to exist in the court records, and I'm not going to spend Imagos money on that because that's, to me, just a waste of money. I was there. I know what happened. Nothing was terribly interesting from the legal perspective, and I got the order that I need, so I don't need another piece of paper from that, so that's fine. Question from Jack Decker. How about setting up a GoFundMe for YouTube creators affected? Absolutely. I probably cannot set up a GoFundMe just automatically, like just on my own. I would probably need permission from Imagos, one, and permission from the YouTuber under the rules of professional conduct regarding concurrent conflicts of interest. I'm sure that there would be a limit to the number of people I could represent in a number of different circumstances. So it would be very specific. They would have to be people, involved in the Imagos side of things. RCR. I don't represent RCRU or any other properties that have been taken down by defendant. So I'm probably going to avoid getting involved in that unless somehow our needs all align at one time. Right now, the situation seems to be being handled, and I expect that we'll be able to continue to handle it. If there's someone out there who is also suffering an irreparable injury that they are not going to be able to recover from, definitely talk to me. We'll figure out whether I can help you or whether we can find an attorney for you or something like that, so that we can get you relief as well if defendant is doing something to your channel. I know there are a few of you that were severely affected, but I'm not entirely sure whether you're interested in representation or not. So if that's true, hit me up, not on the stream. Chris Wallace. Here in the UK, vexatious litigation is notoriously difficult to push through the court unless you get a sympathetic judge. What's the state of frivolous litigation in the US? It's pretty much the same. Judges do not like frivolous copyright litigation much at all, and generally make problems for frivolous copyright litigants. So the judge will give defendant here a chance, and if defendant is not going to be able to come up with something real, then defendant is going to get thrown out of court. Question from Laser Kid. Is there any chance specifically of you bringing up what's happened with River City Ransom? River City Ransom is a very similar situation. It is being handled by separate attorneys, and I cannot talk about it because I may have some confidential information, and I need to be careful. I've been given permission by Imagos and by Don to talk about all of this, so I'm clear of my confidentiality rules with that side of the case. As far as things I know about RCRU and what they are doing, I'm going to keep that very much private and let them control their message there, if that makes any sense. Also, many people are asking about H3H3, and there is no H3H3 update yet. Sorry. The judge has not issued any ruling at all since March 17th. I check every day. I did check earlier today, just in anticipation for this stream. I have not checked between noon and now. So if the ruling has come out between noon and now, it is 10:30 p.m. So in the last 10 and a half hours, then I missed it, and someone will have to alert me, and we'll go right back on live stream and go into that update, because I know you're all looking for that too. So no, that hasn't. That has not been updated yet. I just saw Joseph asked, what about the claims on Turner Broadcasting? As far as I know, nothing is happening there. They did not respond to her claims. Alex was able to do things to YouTube because of the DMCA. Turner hosts their own stuff. What's the worst that she could do is send a takedown notice to a video that's hosted on a third-party platform. I don't know that she's going to be very successful going after Turner. Thank you. Okay. So, is it realistic for Imagos to seek compensation for damages? Yes. So what are we seeking? Imagos is seeking a declaratory judgment, a piece of paper with the judge's signature on it that says we own Star Mazer and Alex does not, and that we own the music to Star Mazer and Alex does not. and a piece of paper prohibiting her from filing further DMCA notices on anything related to Star Mazer. And then monetary damages. No, we're not looking for something like an apology. We're just looking for mostly the first stuff, the injunction and the declaratory judgment, and then we'll be seeking a monetary damages judgment, and then we'll see what we can collect and how we can collect from Alex. If there's no opportunity for the rest of Alex's life to collect anything, whatever. But if defendant at some point decides to, if defendant at some point makes money or gets whatever, has some kind of income, we'll be able to reach that based on a monetary judgment. So it's not a very good idea. Sorry, they're still celebrating July 4th around here. Oh, shout out to Matt. How you doing, man? That's my buddy Matt. He's my ex-girlfriend's brother, and I think he's still here. I think he's still here till tomorrow. So, Matt, let me know if you want to hang out after this. Wait, why are we saying the stream ended? I'm still live, right? Right? Oh God, what's going on? No, it still says good. What are you talking about? Stream ended. Okay. What if Alex files for bankruptcy? Does Imagos lose monetary judgments? No! Bankruptcy does not discharge. That's the word for when you get rid of your debts in bankruptcy. Bankruptcy does not discharge your tax debts, your student loans, or your judgments for intentional torts. An old Latin word for wrong or for hurting somebody is called a tort. And what Alex has done here would fall under a classification called intentional torts. And if she attempted to declare bankruptcy to get out of a judgment against her, I would go to court objecting to her bankruptcy declaration on our judgment because it is an intentional tort and she is not allowed to discharge that. So we'll see what happens. I was not able to find what's dead on YouTube. Don't tell me, Jack, that we're dead on YouTube. What's dead on YouTube? I look fine. What are you talking about? Anyway. Yeah, we're fine. Okay, so let me check to see how many more questions there are. They're just, okay, buffering issues. Yeah, I'm sorry. I have this set to low latency so that we could have a little more interactive of a discussion. And so, yes, some of you will get some buffering because we're at 6 megabits per second. Sorry. Will this set a legal precedent to prevent spurious takedowns using the DMCA? Yes, it's possible. It's also entirely possible that this might be solved by a different resolution, by some kind of settlement between the parties, and it might not end up being precedential. If Alex really does pursue defending it all the way to the end, like the cookbook case that we just read, then yes, we'll be seeking basically a precedential ruling. I really think of this case more historically speaking than precedentially. The most precedent I expect is a judge may clear up what we should do when someone files a large number of illegitimate DMCA claims. Maybe that's a new thing that hasn't really been ruled on before. Alex has raised the issue that Star Mazer DSP is different from the original game, and you've pointed out that doesn't matter. Could you go into why that is in more detail? Well, she's right that it's a difference. If she really did work on two completely separate projects that had two completely separate contracts, one of which had a different work for hire clause in it than the other, that would be something. I've only seen one contract, and I haven't seen any evidence whatsoever that that contract was not the applicable contract for Star Mazer DSP. She has just said she doesn't think so. That's not a legal thing. That's nothing. That's just someone's opinion. That's somebody's speculation and conclusion. That's not a fact. So what really matters is what she was hired to do. If the terms of the contract say you're going to create this work titled Star Mazer and you're not allowed to work on anything else, I don't even know how that would work because they've got the same name. I mean, one Star Mazer DSP. I don't even know how you can claim it. They aren't the same project. But okay, let's say that they were two separate projects. Let's just follow this hypothetically. Where's the evidence that she started a new project? Did she sign a contract for the new project? Okay, maybe she says that she didn't. Okay, then did she do any of the legal research to understand what happens if she works on a commissioned work for a larger audiovisual production without a contract? Imagos still owns the contract, or still owns the copyright. So she obviously has not done any of the research, and unfortunately for her, this standard that we just went over in the cookbook case is going to apply, and she's going to be responsible for attorney's fees and costs. And just because the DMCA 512F says that you have to make a subjectively reasonable look at fair use or whatever on your misrepresentation, that doesn't apply here. She's been objectively unreasonable under this costs and fees standard, so she's going to lose, in my humble legal opinion. In the amended filing, you mentioned that defendant believes they are judgment-proof. What is the significance of this? A judgment-proof defendant is kind of a legal terminology for someone who is on a source of income that can't be reached by a judgment. So person who's on Social Security disability and has no other income, you probably aren't going to be able to garnish their wages or garnish their Social Security disability. Certain kinds of inheritance are judgment proof. Certain kinds of trusts are judgment proof. So if a person has managed to get themselves into a situation where their income is low enough and the sources are protected, then you can get a judgment against them. You can win all the court cases against them, but you can never collect any money because unless, of course, they willingly pay you. So you've got to now just convince them to just pay you. But if they know that they're judgment proof, which defendant has at least alleged that she knows she is judgment proof, and I don't know if she actually is, but she's said it. If that's the case, then we won't be able to collect any money. We'll be able to get all of the pieces of paper that says we can get the money. We just won't be able to actually collect it because there won't be anything to collect at the end of the day. However, that doesn't mean that it goes away. That doesn't mean that the case goes away because I'm going to get frustrated and not collect any money. No, we're going to get all the way to there and then hold that piece of paper over her head until she either acquires money and pays us or doesn't, or maybe there's a happy ending if I don't know. I don't want to go into that because that'll start to sound like an actual legal offer, and we're not making that at this time. Can I speak briefly to this press coverage? Yes. Why do you think I'm doing these live streams? Why do you think I shine a gigantic spotlight on the way things really work? Because look what happens. You can now identify when the press spin a story. You can now identify the motivations. You can identify the lack of research. You can identify the lack of journalistic integrity and ethics because you know the real story. So that's why we're here on a live stream, because so many of you will be able to take a real piece of information away from this. You might still have an opinion that disagrees with something. You're human, and I'd love to have meritorious disagreements with people. What I don't like is when people hide information or misstate things with the intention of getting away with some kind of agenda or something like that. And you've seen that now, and it was easier for us to deal with now because we have maybe not control of the message, but at least we have a voice in the message. When the litigation in this case is concluded, will that clear all the DMCA strikes for the 70 affected YouTube creators? How long will that take? No. The litigation as set up right now is just Imagos against Alex. And so if you want to clear up things with YouTube, you all have to go to court and get this cleared up. And so if you are that concerned with your particular strike or claim from defendant Alex Maurer, you need to be either getting your own attorney or figuring out how to join my lawsuit or contacting me. And yes, I realize some of you have already contacted me, but working with us trying to figure out how to join you to the lawsuit. You will most definitely be asked to be witnesses or make statements. And I may end up having you all have to join as like a class action or something like that under the joinder. So, hey, this 35 days or 32 days that we've got, or I guess it's 30 days from now, for Alex to find an attorney might be a blessing in disguise as we can answer all those questions and try to get people joined to the case if necessary. I might even be able to contact the judge and see what the judge's clerk says the judge would prefer as far as us going forward. It could be a very big deal if there are really 70 plus YouTube creators affected. Next question. Do I think Alex is being truly frivolous? She did have an attorney in March write up a letter to Imagos. The problem is I don't know what that letter, I don't know the basis, excuse me. I don't know the basis on which that letter was written. She may have called that attorney and told him a different set of facts and had him write that letter. It may have been altered. I'm not sure. I'm not accusing anyone. I'm just saying that letter was unsigned. I did contact that attorney, and he did tell me that letter was not cleared to be sent. It had not been finished yet. So it's very possible there were things that were meant to be added, or possibly there were things that were omitted from it. I'm not sure. Podcast status. The podcast is dead. The podcast will become again. We will do a podcast. I will need to be working on it with a new host, and we'll go from there. And hopefully there will be I don't know what happened to the third episode. I'll check up on that. We did shoot or record the third episode, and then it has not been released. So I will have to look into that, and we'll find out what's happening with the rest of the podcast. As far as a schedule for that, I can't commit to anything yet because I kind of forgot about it until you mentioned it. So we'll get on that. Brandon, please make a note that we need to remember to restart the podcast now that we have some stability in that area. The native Lova. How do you think she will handle the hammer of reality? How would you want her to react? I think we've already seen a little bit of the handling of the hammer of reality. The court order has been more or less obeyed. I haven't seen a major violation of the court order. I haven't really even seen too much of a minor violation. I think there's maybe one arguable thing that's out there that I might or might not challenge. It might not be worth it, but I think we've seen that when I drag her into court, she suddenly realizes, hey, my actions do have consequences. That said, her behavior was odd enough that I did not trust that the threats were not real. I thought I gave the threats credibility. Even at one point wore a stab-proof, bulletproof vest to court, and made sure that I got in and out of the building as quickly and securely as possible. At one point, security escorted me through the building, so it was all very, very concerning. And thank you very much to the member of my community that contributed to the purchase of that vest. I hope I have to use it as very, very little as possible, but it was very reassuring that if I did get stabbed, it wasn't going to puncture me very much. So thank you for that. Does the U.S. have anti-SLAPP laws? Would they apply in Alex's DMCA claims? Probably not. I could try, though. We don't have an anti-SLAPP law in Pennsylvania that I'm aware of. If you're wondering what I'm talking about, SLAPP is a strategic lawsuit against public participation. SLAPP, strategic lawsuit against public participation. Let's pretend I'm a critic. I criticize your product. Maybe I criticize Monsanto. So maybe somebody like Monsanto then sues me. This is a hypothetical, Monsanto. Please don't sue me. Let's just say that Monsanto sues me. If my criticism is founded, if it's not actual defamation or some other unprotected form of speech, then an anti-SLAPP statute is a law that says Monsanto gets extra damages, that I win extra damages against a plaintiff that files a lawsuit just to silence my criticism. Why I'm using Monsanto, I don't know. I don't like Monsanto. But that's just a hypothetical. If a plaintiff sues and it's suing over your protected speech, and your speech is not, like I said, a lie or defamation, you're not saying something that's false, a false misrepresentation, then your speech is protected, and in a state with an anti-SLAPP statute, you would have an additional defense and cause of action against that plaintiff for having brought that strategic lawsuit against public participation. So, holy mackerel, we are almost 2 hours into the stream, so why don't we finish with some Star Mazer, if I can bring it up here. I didn't get a chance to test it, so we're just going to launch and see if it comes up here. I want to thank all of you for joining me. It has been a wonderful stream. It has been a very tiring adventure. It has been a worthwhile adventure, and I don't regret it at all. However, it has been a very tiring and exhausting adventure, and I'm looking forward to a little bit of regular life before getting back into the swing of it. So why don't we start some of that with a little Star Mazer. And I'm going to, yes. We can turn that, yeah, there's desktop audio. And let's launch Steam. Steam's already launched. And I'll still have the chat on the upper screen, so I'll still be able to see what you're saying. Let's see if it's going to come up. Uh-oh. Yay! Vberg56 asks, where can we find the court documents? You can find the court documents on leonardjfrench.com. All right.
The city is in ruins.
You're no match for me, sweetie. Not at all.
Here's Star Mazer, guys. Star Mazer DSP, excuse me.
Push the Gel invasion force
Don,
back.
Don really wants me to keep making that distinction.
Collect carbamite to power your weapons. Your weapons are Gal level 2.
Game volume too loud?
Massive bonus score.
Alright, hang on. I'll see if I can fix that. How's that? Any better?
Weapons are now level 3. Maximum damage.
Yeah, I'm pretty sure Don and I grew up in the 80s.
One shot, one kill.
How's the volume now? Much better? Okay.
Absolutely badass.
This is not the Alex Maurer soundtrack. This is the Arcade High soundtrack.
Take it to the planet's surface.
Jeez, I've never played this well any other time, but now when I gotta show it off, it's working. Great. Of course, now I said that out loud.
Admiral, sweetie, I've never seen aliens like this. Absolutely badass. Absolutely badass. No, I'm hit. That was rough, but it only gets rougher.
Off the planet, soldier.
Thank you for the donation, Matthew.
That's right. Guys do.
Oh. Ah! Alright, one pilot down.
I came to kill aliens and troll them, and I'm all out of gum.
Get me out of here. There we go, I want to be right here. No!
Prepare thyself, alien.
I was doing so well.
That's right.
There we go.
Great job.
All right, 155 ain't bad.
This is the
I can buy some pilots on the next run through.
I've never seen one of those before. So many bullets. Boom, baby.
We've never seen these variants. The Gel must be making a new fleet. Watch your back, soldier.
All right, 191.
This is the calm before the storm.
Ah! Ah!
That hurt!
Wall of bullets.
Be careful of those asteroid chuckers.
Ah! Alright, so when you die in this, you gotta spend the score to get better pilots and try again. And you can buy your way into a better list of pilots. So here I could spend, basically all my score buying as many pilots as I can afford.
He's pretty pricey though.
I happen to like pilots that have the puncture beam.
Yes. Bro, yes.
Yeah.
None of which these are great.
Your command.
Sir, yes.
Sir, yes.
Bro, yes. On deck.
The infinite salvo is cool.
Reporting.
I like that one.
Yo, on deck.
Report.
Yo, I'm ready.
Hey,
sir.
ready.
Yeah, but hey.
Reporting
And then
from
I guess we'll try
mission
this
has a
guy.
high probability of failure.
So now I got those 3 pilots in that order to go again from the beginning.
Experience the full force of F Squad!
I can use some wet food. It's wartime, pilot.
I am a hollow reed.
They're coming from above the clouds.
Yeah, I guess it's game over. I don't know. We play a lot of PUBG. Thank you, Alex.
Blast these ships before they make it to the planet's surface.
Killed it! That was close.
We've never seen anything like this before, pilot. Good luck.
I am a hollow reed.
Admiral, these ships are all new! Admiral, they're pretty good shots! Sanctum base, I've penetrated their forward assault.
Take this fight off the planet, soldier.
was first pilot.
Those alien bastards are gonna pay for shooting up my planet. That guy's new. You missed because of course you missed. Oh yes, sonny.
All right.
Good work, soldier.
Yes, Brian, thank you. I do try to let the carbonite combine. I am a leaf on the
This is
wind.
the Telkeen Supercluster.
Is that the Idnex?
We've never seen these variants. The Gel must be making a new fleet. Watch out, pilot.
Admiral, I think we're clear. The yacht belongs.
Ah!
Witness me!
Initiating transmission on 2600 Hertz.
Be careful of those asteroid chuckers.
Invariant parabolic mean diameter.
This is not my favorite pilot here. The computer.
The Gel fleet is vast. Beyond imagining.
Yeah!
Damage to paint. Shutting down.
Ah!
10, 9, 8, 7, 6.
Don't get too comfortable.
All right, one more time
Gel
through,
will
and then
not
I'm gonna
stop
call
their
it
assault.
for the live stream.
The fight's not over, soldier. Use your score to buy a new fleet and get back me out there. One of the available pilots
Oh,
has
who's
a
this?
new weapon to unlock. Check it me out.
Bunny Killmaster. Nice.
Yeah, but on
All right, let's look.
reporting.
Hey, on deck.
Sir, yes, sir.
Puncture Strike Infinite Salvo. Yeah, that's what I like.
Hey,
Yeah, boss.
yo, Hell yeah.
Hey. Yeah. Reporting.
Let's fly.
Hey.
Here we go.
Hey. Of course.
Of course.
I'm here. I'm ready.
All right.
This is exactly what I've been training for.
This is exactly what I've been training for.
I can use some wet food. It's wartime, pilot.
Yeah.
They're coming from above the clouds.
Take that.
That one, yeah. Oh.
Hey.
Oh no!
One shot.
Damn it!
Myself, alien scum.
Blast these ships before they make it to the planet's surface.
Nice.
We've never seen anything like this before, pilot. Good luck.
Leandro Pontes, you're closer than you think. Don's talking about it.
Whoa, look at the guns on that thing. That's right. I am a hollow reed. I am a hollow reed. I am a hollow. I've never really understood that phrase. Admiral, sweetie, they're pretty good shots.
Take this fight off the planet, soldier.
Whoa, just missed me.
Woo!
Whoa, look at the guns on that thing. Boom, baby.
Woo!
Great job. Be prepared.
Whoa, that guy's there. Back at you.
We've never seen these variants. The Gale must be making a new fleet. Watch your back, sir.
Ah! All right, last ship.
Cheers for the fleet.
Yeah.
Wicked. It's calm up here. Too calm.
Careful of those asteroid chuckers.
Oh, yeah.
The Gel fleet is vast, beyond imagining.
Admiral, think we're clear. Not for long. That's right. Nailed it.
Oh, that was easy.
Great
3
job.
tensors, and that just takes out all 3 of them. Nice.
This is the Noomspot Gate.
Oh, I hate the plasma balls.
The enemies, they keep coming.
They're a hive mind pilot. They all aim together.
Ah!
No good.
It seems like the Gel have nearly infinite variation.
Ah!
Oh, just missed me.
Always die to those things.
Yeah, that's what I thought.
This gate connects the galaxies.
Whoa! That was the end of that. I didn't realize they were going to come from behind while that thing was there.
Don't get too comfortable. The Gel will not stop their assault.
All right, everybody. Thank you for joining me. I think I'm going to call that the end of the stream and get back to the rest of my game here in private and in peace. So thank you all for joining me. Thank you especially to my $50 plus Patreon supporters, Joshua Meinzinger, John Cripps, Baxorn, Westin Lohne, and John Steele, I think. And who else was in there? I'm not entirely 100% sure. that I have it in front of me at this moment in time, but they're in the description below. So are all the $5 plus supporters who are also scrolling on my panel behind me. Thank you all for joining me. Don't forget that you can join us for the live discussion on my Discord server, which is also listed in the description below. I guess I'll see you in my next video, as I've forgotten everything else that I have to say. So thank you very much for joining me. I'm Leonard French, your favorite copyright attorney. Have a great weekend.